It's my pleasure to introduce Robert Cusimano, who's a graduate of Penn Law and also the General Counsel and Secretary of ACE. He's had a very distinguished career as an attorney, and he is also a supporter of the idea of promoting rule of law, thinking about rule of law, what it means both as a kind of an intellectual exercise as well as a practical one. So I will now turn it over to Bob and to the panel. Thank you. Please keep eating and enjoy the conversation.
Thanks, Amy. Good afternoon, everyone. I'm Bob Cusimano, General Counsel of the ACE Group. I used to be a trial lawyer, and it's really nice to once again choose to talk rather than eat. I also want to say on behalf of the ACE Group, we're really pleased to be a part of this, and I personally am very pleased to be on the same dais with these gentlemen. We have a very interesting panel for you. It's a little bit of a break from or an interregnum between the morning session and the afternoon session. I'll say first of all that if you have only one doctoral level degree, you're hard pressed to get on this panel. And in fact, there's so many degrees here that we got multiple placards for Professor Lowry. I'm not sure why that is, but maybe he gets one per degree. What we're going to do now is to sort of travel a little bit. We're going to travel away from Iraq and Afghanistan for an hour, and we're going to travel in place and in time, and in one case perhaps in both. And we're going to look at analogous situations and some relevant situations that are not immediately connected to Iraq and Afghanistan. And I think what we're going to do is start with one of the two locations or nations, if you will, that might have some relevance both as a metaphor for what might happen in a country attempting to adopt or refine or reform the rule of law, especially in the early stages of nationhood or new nationhood. And then we're going to move in place and time and look at Japan, and we're going to move in time and look at the Middle East in the past. And the relevance of all that, I think, ultimately will be up to you. But I would say I'll be listening to understand, what is directly relevant and positive, and what are the distinctions, and what can we do about those distinctions where they exist. So our first speaker is Kermit Roosevelt, the University of Pennsylvania, professor of law who has a diverse practice, if you will, working in constitutional law, conflicts of laws, a little bit eclectic, and he's here to talk to us about the example, if you will, of the United States.
Thank you for that introduction. Thank you to the organizers for putting all this together, for inviting me, and thank you, of course, to all of you in the audience for coming here. So I teach and study US constitutional law. I'm not an expert at all on Iraq or Afghanistan. And as you'll see, that means that I can't really come to a conclusion about the question that I'm going to try to address here. But what I want to do is to look at the US experience with our constitutional law and our Supreme Court and ask, what has that really been like? Why have we had this experience? And the importance of this question, of course, as far as other countries are concerned, is that Americans at least generally think, well, we've had a good experience. And we think if other countries could go down this same path, that would be a good thing. So I'm going to talk a little bit about American constitutional history as it's generally understood to have unfolded, and then about why we've had this experience. So the question, of course, is going to be whether the factors that produce this American experience do or could exist in other countries, such as Iraq or Afghanistan. And that's the question whose answer I really don't know, although I'm sure many of you in the audience would be able to tell me. So going back to America, what is the American story? Well, generally speaking, and this is perhaps a little bit less true now than it was maybe 15 or 20 years ago, but generally speaking, the story that Americans tell ourselves is that we've got a great constitution, right? It's served us well for over 200 years. It's given us a wonderful system of government in its structural provisions. It's embodied our deepest ideals in its individual rights provisions, ideals like liberty, equality, free speech. And the Supreme Court, captained by these heroic justices, has drawn the wisdom of the founders out of the general phrases of this document and has sort of led Americans to their better selves. So this is a story that pays a lot of attention to the writing of the Constitution, which is appropriate that we're here in Philadelphia. Of course, it happened just on the other side of town. And it pays a lot of attention to great justices, people like John Marshall, Oliver Wendell Holmes, maybe Earl Warren, although he's a little bit more controversial. And it pays a lot of attention, in particular, to Brown against Board of Education, where the Supreme Court said racial segregation of public schools is unconstitutional. It pays maybe some attention, but probably less, to other decisions, maybe protecting women's equality, or protecting other things that might have been unpopular at the time the Supreme Court decided these cases, but looked like good ideas in retrospect. But basically, the point of the story is this. Our Constitution is great. At least some of our Supreme Court justices have been great. And working together, they've made us a great country. So this story, or elements of it, are part of what you could really call the American civic religion. There's a sort of religious attachment, for instance, to the greatness of the Constitution. If you're suggesting that maybe the Constitution should be amended, you might come across as actually sacrilegious, right? You're implying that there's something wrong with the Constitution. You might also come across as unpatriotic, right? People might think, well, you know, you're saying there's something wrong with the Constitution is central to American society, you're saying there's something wrong with American society. We've got this sort of veneration of the Constitution, a resistance to any suggestion that there's something about it that needs to be changed. It's sort of like a religion, and, you know, that's actually fine, I would say. Societies need things to cohere around. The Constitution is a symbol of America that we hold very tightly to. Now, however, in interesting ways, it's also sort of unlike a religion, because people who would certainly never say our religious religion, our spiritual religion, is good for other countries too, are perfectly happy to say our civic religion, our Constitution, is good for other countries. And so this is the question, right? We've got this basic idea. The basic idea is our Constitution worked so well for us, a similar setup is going to work well for other countries. So write yourself a similar Constitution, give yourself some individual rights provisions written in general terms, give yourself a Supreme Court, and maybe you will be great like America. And if it doesn't work out so well, then the problem is probably you. You know, your judges aren't as great as our great justices were, or your society is not as committed to the rule of law as Americans are. So that's the idea that I want to examine here. And the first thing to say about it, I think, is that the story it tells about the American experience is not really true. It's what we like to tell ourselves. We like, for this sort of civic religion reason, to imagine an unbroken thread that connects us to the framers. And that thread is the Constitution. But in actual fact, of course, that thread broke. It broke in the Civil War. And in the Civil War, Americans killed about as many Americans as foreigners have killed in all of our other wars combined. So the American experience that leads to the Civil War is actually not a path that any other country would want to go down. Now, it's true, of course, the Civil War came about in large part because of the institution of slavery, and that was a unique stressor on American society. You can't blame the Constitution for that. You can't blame the Supreme Court. It's also true, though, if you look at the years that led up to the Civil War, you see a bunch of attempts by the Supreme Court to avert war. Attempts by the Supreme Court actually using the Constitution, using its general principles and its individual rights provisions to protect, well, basically to protect the right to own slaves. And actually, looking back on those decisions now, we think they were bad and shameful. So what does this mean? Well, maybe the American success story is a little bit more limited. Maybe we should limit it to the post-Civil War Constitution. And that is actually what people usually are thinking about when they have this heroic narrative in mind. They're thinking of the Supreme Court as a moral leader with the civil rights movement. But the story there is a little bit more complicated too. The story of the civil rights movement is not really about the court acting by itself. It's about the court, yes, but it's supported by Congress with the Civil Rights Acts of the 1960s. It's supported by the President with the 101st Airborne at the schoolhouse doors in Little Rock. So the Civil Rights Movement is not really an example of the court leading the country on its own in the right direction. It's more an example of the national government imposing its will on a minority of states. It's actually really basically the Civil War story, but without the 600,000 deaths. And quite possibly it wouldn't have happened that way. It couldn't have happened that way without the Civil War. More generally, the point is, this historically is what the Supreme Court has been good at. It has been good at enforcing a national consensus against a minority of states that resist it. And it has actually done a lot less well in other circumstances. So think about those other circumstances. What happens if you've got the court and sometimes Congress and the President are supporting it, sometimes Congress and the President are opposing it? An example of that might be the court's abortion jurisprudence. What's happened there? Well, the court has not led us to any stable consensus. Access to abortion is actually getting harder, especially for poor women, pretty steadily year by year now. You might think that's a good thing, you might think it's a bad thing, but in either case, the court made its move and the country really didn't follow. The court has not succeeded very well with its abortion rights cases. So what happens when the court is not supported and actually opposed by Congress and the President? Well, for examples of that, you might look at wartime civil liberties cases. You could look at them during our current so-called war on terror. You could look at some from the past, notably maybe the internment of Japanese Americans during World War II. Or you could look before the Second World War at the court's opposition to Franklin Roosevelt's New Deal, where again the Supreme Court took on the President and Congress. And in all of these cases, basically the court lost. So, with the possible exception of our current situation, where the outcome kind of remains to be seen, the court really didn't achieve very much at all. So, what does this mean? It means that our heroic narrative, the one that Americans like to tell themselves about the court and the Constitution, is not really about the court leading the nation forward. It's more about the federal government dragging along a minority of recalcitrant states. So if you don't have that structural setup, if you don't have the federal government versus a minority of states, you really don't get the heroic narrative. You get protracted, apparently insoluble conflict, like we have with abortion, or you get the Supreme Court failing to achieve its goals, like we saw with the Japanese internment, or you get judicial decisions that have no practical effect, which is what we're seeing now with the Guantanamo litigation. So the general point that I would take from this is other countries, they can adopt general individual rights provisions, they can create Supreme Courts to enforce them. That might be a very good thing to do, it might not be, but you certainly should not necessarily expect that their experience is going to be like the American experience with the civil rights movement. Whether the experience of other countries will be like ours doesn't have that much to do probably with the quality of the judges. It doesn't have that much to do probably with a culture of respect for the rule of law or the judiciary. Both those things are important, of course, but they're certainly not sufficient. The most important factor, this is my big point, in creating the kind of narrative that we like to tell ourselves about the Supreme Court, the Constitution, and American society, the most important factor is actually federalism. And it's actually the fact that on this particular issue, which is really the residue of the Civil War, we had the national government united against a minority of states. If you don't have that structural setup, you don't get the kind of thing that we like to think the American Constitution produces. Thank you.
The next stop on our tour is Japan. And to talk about the experience of Japan, Professor Eric Feldman, whose background lies in law and social policy and perhaps even sociology and the intersections among all of those. Professor Feldman?
Thank you. First, thank you, Mr. Kuzmanu, for making the heroic effort to actually find and identify links between our disparate papers. I love how
I do a
you've
lot
done
of
it
traveling.
so far. I also want to thank my colleagues at Penn, particularly Amy in the front and Lauren at the very back. Organizing this kind of meeting is an extraordinary undertaking, and you guys, I think, have just done a wonderful job. This is one of a variety of new kinds of international activities that are going on in the law school. So I'd also invite everybody here, many I think here for the first time, to continue to stay connected to Penn and come back. A number of years ago, my older brother went off to do a master's in anthropology in Cambridge and went to the May Ball. And when I asked him what it was like, he said, well, you know, everybody was in black tie, and I wore the only suit I have, and it was green. And I said, well, what was that like? And he said, well, I felt like a parakeet at a party of penguins. and that's me today. Because, as Kim said, Iraq and Afghanistan are not areas of my own expertise. So I want to caution myself to make sure not to say anything of particular relevance about those two places, except with regard to Japan. And I really leave it to all of you to help me figure out, or help us collectively figure out, what Japan might add, what a conversation about Japan might add to the understanding of U.S. involvement, particularly in Iraq. I know this is a subject that's come up regularly. It came up at dinner last night. One can find a variety of articles by distinguished scholars of Japanese history and society: Chalmers Johnson, the political scientist; John Dower, the historian; Frank Gibney. And interestingly, all of those articles have a title that's basically a four-word title, and they're all titled "Iraq is not Japan," which is wonderfully uncontroversial, I suppose, one of the few unambiguous statements one makes in this law school. But I think they're right. And let me just offer what I see as five important factors to the successful democratization and successful economic development of post-war Japan. Five that I selected based, again, on my rudimentary understanding of Iraq and Afghanistan, but five I think will at least invite a conversation. The first is that one really needs to appreciate the importance of strong bureaucratic infrastructure to what went on in post-war Japan. And you can see that in a variety of ways. The bureaucracy in Japan has for centuries had an image of respect and legitimacy. The early bureaucrats, after all, were the unemployed samurai. They no longer found it very lucrative to defend and fight for their feudal lords because Japan was at peace, and so they looked around for something else to do, and they ended up becoming bureaucrats. But they carried with them a good deal of social respect. And the Japanese government, both before the Second World War, really for centuries before, and still today, continues to be a place where the best and the brightest end up. The smartest graduates from the top universities are really more likely to go to the Ministry of Finance than they are to private enterprise. Now, one might think after the war that the American occupying forces would have purged the bureaucracy, given the fact that so many senior government officials were involved in Japan's build-up to the war. But MacArthur and others understood early on that they had no way of governing Japan without the help of those who had previously been governing Japan. So the story in the Japanese bureaucracy, pre-war, post-war, is a story of continuity rather than change. There were symbolic purges, there were the Tokyo war crimes trials, but nobody who has studied that period would suggest that the bureaucracy was cleansed. Instead, what one learns is that the senior important bureaucrats who knew how to operate with their ministries, knew how to collaborate across ministry borders, and knew how to govern remained in place. So the existence of an intact, well-trained, respected bureaucracy was absolutely crucial, I think, to the story of the Japanese miracle or the Japanese post-war development. Second, While, and again, you'll have 5 points and they'll get shorter. The second is that while the tendency to describe Japan as homogeneous drives me and everyone else who works on Japan nuts, it is probably the case that compared to many other places, Japan lacks the sort of religious or ethnic or racial divisions that make social stability so challenging in certain instances. There's, of course, in Japan, examples of regional hostilities, North versus South, feudal Lord X against feudal Lord Y. But they're never rooted in deeply held and deeply divided religious convictions, never linked to ethnic identity, never a reflection of racial hatred. On top of that, one has and had in Japan in the post-war period a quite literate and quite technologically skilled population, which also added to the ability to unify and govern the country. So when the US occupation forces arrived, again, right off the bat, they found a population with a collective sense of national identity and national purpose that lacked the kind of cleavages that would have really challenged stability. The third point, the idea of democracy was not new. As much as one might like to think that General MacArthur and his minion introduced democracy to Japan, there's a period of Japanese history in the 1920s, well before MacArthur arrived there, called Taisho democracy, where the idea and reality of a two-party system, of the right to vote across a broad spectrum of the population, the rights of organized labor, etc., were all rights that were aggressively fought for, defended, and emerged politically in Japan. So the US occupation forces weren't sort of parachuting in with a brand new idea that was not understood or tested in Japan. Taisho democracy faded out in the, on the onslaught, in a sense, of the uprise of a military government in Japan that led to the war. But democracy had been in Japan before, and there was a good deal of receptivity. The fourth point, easily stated, I think, preparation matters. And from very early on, some suggest from the moment the beginnings of the attack on Pearl Harbor were noted, the idea of occupying Japan was on the agenda in the State Department and among American planners and government officials. So when the American forces got to Japan to begin the occupation, I don't know if one could say they were ready, but they were a lot more ready than they would have been had they not put any thought and planning into this. There were a lot of people who were trained in the Japanese language. There were a reasonable number of scholars trained in everything from Japanese law, Japanese politics, Japanese anthropology, sociology, history, etc. We had thought about and debated in Washington the nature of the occupation, the goals of the occupation, the kinds of challenges the occupation might face. So when the US occupation forces arrived in Tokyo and took up headquarters in what's now called the Ginza, they were relatively well prepared, not perfectly prepared. I don't know what that would even mean, but they had begun preparations and had laid a groundwork. The fifth and final point is that the US occupation of Japan was considered morally and politically legitimate by almost all parties, by the Americans, by the Japanese, by the world community. And there's a few ways of looking at that point. One is to remember the debate about whether the emperor should be tried as a war criminal or not, and the very careful and strategic decision to not do that, but instead have the emperor renounce his divinity on national radio. Of course, the Japanese, prior to the war, you couldn't look at the emperor because you can't look at the divine, so you had to crawl backwards and keep your eyes closed. But suddenly the idea was that the emperor was a mere mortal, and the emperor was involved with, engaged with, but subservient to the Americans. If you ever wander into the American embassy in Tokyo, you'll see this classic photo of Emperor Hirohito and General MacArthur. And General MacArthur is enormous, right? Broad shouldered, tall, and emperor here, he's just like this little shriveled man. And that was the image of the emperor that emerged to say, look, eras have changed, tables have changed, and these guys, General MacArthur and the others, are in charge and ought to be in charge, and I, the emperor, say so. Another way of looking at that same point is John Dower, the Pulitzer Prize-winning historian of Japan, wrote a book called Embracing Defeat. And the notion of defeat in Japan was widespread. The idea that we had created and entered a war in an illegitimate way and then lost, and now it's our turn to be governed and ruled and put back into place, was widespread. So the American occupiers found a population receptive to being rebuilt. And the last way of thinking about this same point is that I don't think there's a single documented incident of the American occupation of serious violence perpetrated against the occupying forces. Of course, there were fights. There's always fights. But there was no organized violence against the American occupation. It's not that suicide bombing is an alien concept to the pacifist Japanese. I mean, you've all seen the Tora 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 and the kamikazes and all of that. So blowing oneself up for one country, that was considered perfectly appropriate. It just wasn't appropriate to blow oneself up for one country against the occupation forces, because that would not have been in one's country's interests. So there weren't structured attacks. There weren't efforts to blow up the American occupation headquarters. There was nothing of that sort. There's volumes and volumes written about the U.S. occupation of Japan, and so it's difficult to bullet 5 points. But those, at least, I hope, suggest a few things that the American occupation did to really successfully help Japan both democratize and develop economically, and I hope they provide some fodder for discussion afterwards. Thanks.
Thanks, Professor Feldman. Well, let's fly back to the Middle East, shall we? And let's go back in time this time. Professor Joe Lowry has spent his career on the intersection of law and Islamic studies, holds degrees in both areas, and I think is uniquely qualified to give us some perspectives on how history in this region, and in particular with regard to the rule of law in this region, may have some bearing on what we might do today.
Thank you, and thanks to the organizers for inviting me. After these very useful remarks, I think when I travel very far back in time and talk about early constitutional arrangements in Islamic governments, it may seem very far removed from the practical task that you're engaged in here, but I hope it will be relevant and give you something to think about. The principal thing I'd like to do is to qualify the idea that an Islamic state, and I realize that nobody is proposing that Iraq is an Islamic state or should become one necessarily, but that an Islamic state, an idea that is much in the news, creates much alarm in policy circles and is much discussed in many places, that such a state is necessarily one all of whose aspects are somehow directly controlled by God or by Islamic law. And I want to just make the case that this is hardly ever the case in pre-modern Islamic societies and polities. So let me begin, and I should say I'm going to recite a few basic facts of the history of Islamic societies that are probably known to some of you, but I will just use these to introduce some broad assertions that I hope will be provocative or helpful. So let me begin with a recent report that was just released, I think, a week ago in Washington, D.C. on Sharia. It's called Sharia, the Threat to America. And I quote, Sharia, this is from the Center for Security Policy, a Washington, D.C. think tank. Sharia is a doctrine that mandates the rule of Allah over all aspects of society. Specifically, Sharia holds that God did not create the mind free, but in subservience to the will of Allah, as detailed in Sharia. The condition of human beings is submission to Allah, not freedom. And from another passage, Sharia explicitly seeks to replace representative governance with an Islamic state, to destroy sovereign and national polities with a global caliphate. Well, this is all very alarming, and I wonder how people know these things about Islamic law often, and why they think that the Sharia or Islamic law is connected in an essential way with totalizing and authoritarian models of governance. It seems to me, and I speak from my perspective as somebody who studies early Islamic legal thought, that there has always been a basic de facto separation of religious and political authority in Islamic societies, with the religious aspect certainly having considerable autonomy. This changed somewhat in early modern times and fairly drastically in modern times in the colonial and post-colonial periods, when the religious institution became diminished in almost all respects. And this transformation has had an enormous impact on the ways that Islamic states are imagined today by those Muslims who think it's important to have such states. So let me try to give some historical depth to the idea of what could be meant by Islamic government in the past, and maybe this will be useful for thinking about those places where people think that Islamic provisions, whether constitutional or legislative or otherwise, might be useful for thinking about legal reform in Iraq and Afghanistan. So I'm going to talk about four things. First, how did religion become autonomous in Islam? Autonomous, that is, from the state. Then I will mention fleetingly a couple of counter-examples, situations where religion was closely connected with government. Then I will briefly consider some recent attempts by some of my colleagues to characterize pre-modern Islamic political arrangements as constitutional. And if there's time, I may reflect even more briefly on the path from this pre-modern system through Ottoman times and into modernity and the situation we're in today with some modern Islamizing constitutions, although there are people here who are more expert about that than I. So, the early Islamic state, from its very beginnings, was beset by drastic problems of legitimacy. I would say that really only at the very end of Muhammad's career, in the late 620s and early 630s, did he achieve anything like a theocracy in the robust sense of that term. Muhammad's most immediate political successors may briefly have combined political and religious authority, but this came to an end very swiftly, probably already by 656, at which point criteria for legitimacy became a crucial point of debate on which there was little agreement, and the early Muslim community was beset by civil wars over who should lead. Now, some of this disagreement was purely theological. It involved deciding what the criteria were of just rule and who was a just ruler. Some of the disagreement concerned what we might call normal political matters like power, resources, social ties, and so on. But the theological component in these debates was not negligible, and I would argue that it's precisely the failure of the early Islamic state, right after Muhammad's death, to successfully project legitimacy in ideological or religious terms that led directly to the creation of an alternative, imagined political order that expressed itself as Islamic law, a domain of piety and intellectual play, free from the constraints or the sad failures of the political institution. In other words, we can date the separation of church and state in Islamic polities fairly precisely and very early. Now, not surprisingly, there were attempts to control the religious institution. They failed for the most part. Even though substantial disagreement remained over the religious and thus the political legitimacy of the earliest rulers of the community, by the mid-8th century, many and maybe most Muslims who were theologically inclined were resigned to being ruled by caliphs, first from Damascus and later from Baghdad. Technically, the caliphs were the successors to Muhammad's political functions. Caliph means, in fact, successor or deputy in Arabic. But they were mostly only tolerated by the theologically inclined in the community, that is, by persons who became scholars, and that's all they were done. They were tolerated, and that's it. So let me tell you two old stories from the time when caliphs ruled from Baghdad about failed attempts to control the religious institution. The first has to do with an Iranian advisor to one of the early Baghdad caliphs, somebody named Ibn al-Muqaffa. He forwarded, and this is a story well known to many of you, a memo to an early Baghdad caliph urging him, among other things, to resolve conflicts among the jurists because they issued conflicting rulings everywhere, and to do this by promulgating a unified code. This never happened, not at all. And the fact that it never happened tells us that already the religious scholars were not subject to state control, and that they were so diverse in their views and so autonomous that it would have been a hopeless task to try to control them. This is a little more than a century after Muhammad's death. About a century later, another Baghdad caliph tried to institute an inquisition in relation to theological dogma. The point of dogma is very abstruse. It has to do with the ontology of God's speech. Muslim scholars were already trending away from an interest in theology. They were much more concerned with Islamic law than theology, and that trend only continued over time. The attempt to impose the dogma was a miserable failure. The theological principle at issue was objectionable, certainly to many legal scholars, but the real resentment came from being told by the government what to think and the brutality employed to enforce the dogma. And this inquisition was abandoned within 2.5 decades. This event underscored, I think, what concerned Ibn al-Muqaffa, our Iranian advisor to the caliph, that the government was not really able to control scholars, and it added to that lesson the glaring spectacle of government brutality, followed by a moral victory for the religious scholars. Within a century of this inquisition, we see the evolution of more or less self-financing private religious institutions. Private associations of jurists form, grouped around shared legal doctrine. After another century or so, self-financing educational institutions, madrasas, evolve. Also, Sufi orders are relevant to thinking about this, another domain of private, non-state controlled religious activity. Now, of course, in weak pre-modern states, private institutions as these naturally arise to fill gaps, but these private religious institutions, which are characteristic of Islamic law, were given their decisive impetus precisely by the failure of the early Islamic state and the resulting scholarly distaste for politics. Having said that, the relationship between religious scholars and the state was complex in pre-modern times. Caliphs and sultans had resources, but they needed legitimacy. Scholars could confer that legitimacy by virtue of their moral authority. They were, as a tradition from the Prophet tells us, the heirs of the prophets. And I should note that the prophets in the Quran are relentlessly portrayed as speaking truth to power. Scholars needed to balance these opportunities for patronage and resources, such as judgeships or sponsorship of institutions of religious education, against the extremely valuable asset of their moral autonomy, which was precisely what conferred religious authority and prestige on them. As elites, rulers and scholars needed each other, that is true, but their power over each other was also limited. Sultans could not in general coerce scholars, and also could not be seen to ignore the scholars, but scholars had no real power to enforce religious law against the sultan's breaches of it. Are there counterexamples to this picture that I painted? So let me put this differently. One way to think about what I'm saying is that Sunni Islam lacked theocracies in the very robust sense of that term because it never generated charismatic governments after the lifetime of the Prophet. Now, there were charismatic Sunni governments in North Africa in the 12th and 13th centuries. This probably has as much to do with the dynamics of Berber society as anything. And of course, Shi'ism is an entirely different matter. Shi'ism is the dream of the return of the just and legitimate caliph, of a state in which religious knowledge and political authority are seamlessly fused, and mostly it was just that, a dream, until the Iranian Revolution of 1979. No just caliph has returned there, or imam, but very unlike Sunni Islam, a robust scholarly class has remained intact through colonial and nationalist periods and assumed a major role in the direction of the state. And this is a thing which I think is unimaginable in the case of Sunni Islam. Now, let me just conclude by wondering about whether the structure I've described is a constitution. And I'm going to refer to the views of 3 scholars here. Patricia Crona, a very eminent historian of pre-modern Islamic societies and thought, says that this arrangement, the complex symbiotic relationship between the sultan and the jurist, was constitutional. She refers to it as such, but she says it had no teeth, since the scholars could formulate rules to constrain rulers, but no more. The scholars had no power of enforcement at their disposal. Wa'il Halak, perhaps the most eminent historian of Islamic law, who now teaches at Columbia, also describes this as a constitutional arrangement with well-defined spheres of legislative competence, one for the ruler and another for the scholars. And importantly, the scholars' formulations of Islamic law, according to Halak, were driven by the fact that Islamic law was rigorously applied by the state in the context of a well-ordered legal system with a sophisticated and trained judiciary. There is something to both of these views, but for my money, Crona is too positivistic, and Halak is too optimistic about the integration of the political and the religious institutions. Another recent book, I think gets this just about right. Noah Feldman, a professor at Harvard Law, has written a book recently, I think 2008, called The Fall and Rise of the Islamic State. And he argues there that scholars, by virtue of their complex relationship to power, at once aloof and symbiotic, functioned as a kind of constitutional check on the ability of rulers to act without constraint. It is true that the scholars had no de facto power to depose a ruler, but their moral authority and the fact that rulers needed them for legitimacy did give them a position from which They could advise those in power and often affect policy, urge restraint, and so on. So there are three things I'd like you to take away from this. The first is the scholars, or jurists, are the exclusive discoverers and formulators of Islamic law in the pre-modern period. They alone have the authority to pronounce on what is correct Islamic legal doctrine. Secondly, they formulated this law mostly completely independently of the state, and to whatever extent actual states enforced rules of Islamic law. The heart of Islamic law is really a scholastic enterprise, and this emerges very clearly from the fact that the hero of all theoretical writings on Islamic jurisprudence is the scholar jurist who provides private legal opinions based on a carefully elaborated hermeneutic and rules of inference. Judges are not the heroes of Islamic jurisprudence. Their rulings have zero precedential value in classical Islamic law. Third, and perhaps most critically, no Sunni jurist before the modern era ever thought that a Sunni jurist should be the ruler of a state. So I hope that's useful for you. Thank you.
Thank you. Well, we do have some time for questions, and I hope you'll formulate a few while I exercise the moderator's privilege and ask the first one, which is maybe a little complicated, but something that's been on my mind for a while and has, I think, been echoed in maybe all three of the presentations here. It has seemed to me that in developing the rule of law, there's a fundamental paradox that has to get broken, which is that a functioning rule of law requires a belief in the rule of law. And you have a chicken and egg problem that emerges in solution perhaps over time. In the modern world, what you have, I think, in terms of organizing the common wisdom in a country or around the world is a combination of media, propaganda, and outcomes from judicial or other rule of law type systems. And so my question for each of you is, with regard to the United States and Japan and the more historics, or how long it might take.
Well, it's a good question. I mean, how exactly we get to our well-functioning constitutional democracy is an interesting question. I think if you look back at colonial history, we certainly did start, you know, when the American nation starts, it's really not starting from scratch. It's building on this very long legacy of experience with the English common law, right? So we have a long legal heritage and a lot of ideals that we can sort of import into our constitutional system without them seeming foreign. You know, it's a legacy that people are actually happy to claim. So what does that mean in terms of how long it takes rule of law thinking to develop? Maybe a long time. I mean, to find the origins of American belief and adherence to the rule of law, you've got to go back to like the Magna Carta, I think. I mean, because that's what we had to rely on, is this history, and it's a very nice history of England, where this sort of uncontrolled regal authority is eventually forced to abide by some principles. But yeah, I mean, that takes a long time, and it's certainly not something that you can see emerging by itself from nothing in colonial America. I mean, it works as well as it does in colonial America because you have this long English history to draw on.
Yeah, it's a great question, though a hard one to answer. And I think for me the problem is I'm not sure at which moment one can comfortably say Japan now has the rule of law. So if we go back in Japanese history and go back to what, the 7th, 8th century, where Japan imports its first version of a legal code from China, does Japan have the rule of law, or has Japan just borrowed another country's legal system? Or go back to the mid to late 19th century, where Western powers, tired of Japan's unwillingness to engage as a full economic partner, sort of pull out the guns and say engage or else, and unless you adopt a legal system that we consider to be modern, i.e. a European-style legal system, we're not going to consider your laws illegitimate. And so Japan adopts a civil code, a criminal code, it's a code of civil procedure. Is that when the rule of law takes hold in Japan, and then you have the post-war American occupation. And then you have 5 years ago when there's a blue ribbon panel convened, or 10 years ago brought together by the government, and the focus is law reform. And the preface says something like, we need to really introduce and fully establish the rule of law in Japan. It's time to make Japanese feel like governing objects rather than governed subjects. So the sense that even now, where one would have thought that for quite a number of decades the rule of law has been thriving in Japan, and many would say it is, you have internal reform in Japan where the government and the Ministry of Justice say, look, we are having problems with the rule of law here, we need to do better. So I think my difficulty in answering the question is I don't know when that moment occurred in Japan, if ever, and part of it is what does one mean by the rule of law, and what's the evidence one needs to make a determination about whether we have it or don't.
Yeah, this is an easy question for pre-modern Islamic law. There's no doubt that people have a very strong sense of the value of the rule of law. Jurists are committed to stability and rule-bound behavior, and once they are engaged in the enterprise of formulating law, they think that that's incredibly important. So on the one hand, they have a principled commitment to the rule of law. And on the other hand, of course, it's self-interested because they're the people who benefit from the advantages of believing in the rule of law. But more generally, I think pre-modern Islamic societies also had a very strong sense of the value of the rule of law, and that was what made it possible, really, for the jurists to be a kind of symbol of the moral authority that kept, at least symbolically, maybe not always actually, the behavior of rulers in check.
Okay, questions from the audience? Yes.
Two questions, actually. Professor Feldman, we've been talking about exporting American values and institutions abroad. And I was struck by something you said. The Japanese did not commit suicide bombings against the occupation because they realized it was not in their national interest to do so. I'm wondering if by that you meant that at the time, post-war, immediately post-war, there was actually a feeling on the part of the Japanese that this unprovoked, unjust war that we just lost might be the best thing that ever happened to us. We're getting capitalism, we're getting a constitutional democracy, and that they actually thought what America's handing to us is a gift. And so that's my question for you. Certainly it's not the case of what's going on in the Middle East today, in Iraq and Afghanistan, at least not completely. Professor Lowry, you spoke eloquently about the failed attempts of the government, of the establishment, to try and co-opt or control the religious establishment. But I think what's happening when we talk about concerns or issues in Islamic law today, it's the discussion is the exact opposite. And if you look at the Iraq Constitution, there are 3 instances, the repugnancy clause, where no law can contradict an established principle of Islam, where you have the imposition of personal status law that potentially is going to take over what has been in Iraq for decades, a secular law, and you have the role of Islamic judges on the federal Supreme Court. So you actually have the concern by many that it's the religious establishment that's taking over that which was rendered unto Caesar. And I was wondering if you might just discuss, share your thoughts or about that aspect of the debate.
I think there's a lot of truth to what you said on 2 levels. For one, by the end of the war, we're dealing with the Japanese population in a country that's been leveled in almost every inconceivable way. And so you speak to elderly Japanese and they reminisce about wandering in the rice fields, if there were any, looking for crickets, because crickets is what they had to eat. I mean, it's true what the New York Times wrote last Wednesday. Bugs are actually pretty good, and I recommend crickets, but it wasn't what people thought of as an ideal situation. Their houses were leveled, they had no jobs, and so they welcomed, I think, the arrival of the Americans because they welcomed the opportunity to rebuild. On a much more highfalutin level, the senior government officials welcomed the arrangement with the Americans because we thought that Japan was crucial to American military interests. We wanted a base in the Pacific, and Japan was a place we wanted to have our military. And while one might imagine having foreign military forces long-term stationed on one's land would be offensive, and it is to some in Japan, for the government it meant that in combination with Article 9 of the Constitution, which is the pacifist clause, it meant they didn't have to invest, at least not early on the development of a military. And they could focus on economic development, and the American-Japan economic link gave the Japanese a place to sell their stuff. So sort of protected them and bought all of their things, and for many years the Liberal Democratic Party in Japan was sort of a single dominant party, in part because this post-war bargain worked out so well with regard to the Japanese national interest. So I think both for the sort of the men and women on the ground personally impacted, and for the ruling elite who were trying to figure out the way out of the morass, there was a sense of welcomed relief at that.
Thanks for your question. I talk about modern Iraqi legislation at my peril, but I suspect that the consequences of having a repugnancy clause anywhere of the kind you describe, the ideas of provisions repugnant to Islamic law, would be deemed unconstitutional somehow, right, or would be overturned, are completely unpredictable, partly because of the polyvocality of Islamic legal doctrine. I mean, there's not one Islamic legal doctrine, right? It's a conversation. It's much more Talmudic than it is code-like in the sense that it is highly diverse. But the other thing that you say, which I think is actually really important to get at, is you talk about judges applying the law. And of course, this is not the main feature, traditionally anyway, or in pre-modern times of Islamic law, judges applying the law. Judges are marginal. So, I guess, or to put it differently, judges who apply provisions and codes are much more in the nature of technicians. I think this is actually the word Feldman uses in his book, and it's a pretty good point, I think. Because all the responsibility for formulating the law has been taken away from them. So their role, I'm not saying that they might not issue a regressive decision or one that might not be alarming, but their role is so other in regard to applying a legal code, or in regard to applying even a legal code that is based on Sharia provisions, that I just don't think that they have the kind of wherewithal to become the threat that you imagine in that position. I think that is such a circumscribed role in regard to Islamic jurisprudence that it just, it doesn't strike me as exhibiting the kind of danger that you're worried about.
Time for one more question.
Thank you. Professor Lowry, let's see if I can formulate this question. Is the failure of the Sunni branch of Islam to come up with a theological idea of the state and control the state, is that an accident of history because there were no charismatic theological leaders, or is it because of something within the various Sunni schools and doctrines that did not enable them, if I may finish? And if it is part of the Sunni doctrine, we now have groups who are extreme Sunni groups who are calling for Islamic caliphates in Iraq, for example. What has changed in that Sunni outlook?
Okay, so in response to the first part of your question, there's kind of a chicken and an egg problem, because Shia did have a different theology, but they were also oppressed historically by the Sunnis, right, until really early modern times. And this no doubt contributed to their understanding of how political arrangements might be realized. And this is very clear if you read Khomeini's Islam and Revolution, which I think you can buy in a nice paperback version on Amazon. It's well worth reading. The very interesting mix of sort of socialist and liberation theology ideas with traditional Islamic jurisprudence. It's well worth a read, and it's the kind of thing that is less common, I think, among Sunni thinkers today, although that's not really my specialty. And the second part of your question, sorry, can you remind me? Yeah, oh, right, thanks. So this gets back to my point about the judges. Yeah, well, in a nutshell, the major effect of the transition through the colonial and nationalist periods in the Islamic Middle East was to essentially destroy the Sunni scholarly institution. Right now, the process by which this institution became neutralized has its roots in the centralization of authority under the Ottomans. There's no doubt about that, and we could put a Foucauldian spin on it and say that it has to do also with advances in technologies of governance, right? So it's not surprising that private, loose, and relaxed institutions would gradually be subsumed under state control in those terms. But really, it's the disappearance of a robust Sunni scholarly institution, which is something that does not happen for Imami Shiites, right? They still have a robust institution. It's functioning very well. It's diverse and very interesting and dynamic.
Well, I think that concludes our lunchtime tour. Thank you for joining us.